SRIRAM's IS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Coming prelims examination, I am Mayank Bharadwaj presenting you this class. This will be class number 15. Now we have came up with another topic which relates to custodial deaths and what Supreme Court has to say on custodial deaths. Supreme Court has taken a very strict view on custodial deaths. It has set aside the cop's bail. That simply means a cop, a police officer, was involved in the murder of a detained person in the custody. That simply means there was a robbery which happened, and out of this robbery a person was arrested. Now this particular person was in the jail, in the premises of the custody, the police custody. Okay, there are two kind of custody, always remember. Judicial custody, that simply means in the custody of the magistrate, and police custody, that simply means in the custody of the ऑफिसर इंचार्ज ऑफ द पुलिस स्टेशन. आपके जो लोकल थाने में अगर कोई बंद है दैट इज पुलिस कस्टडी, और बड़ी जेल में कोई बंद है तिहाड़ और दूसरी बड़ी जेलों में, तो वो है जुडिशियल कस्टडी. सो अ पर्सन हु वाज इन द पुलिस कस्टडी, दिस पर्सन अक्यूज्ड ऑफ रॉबरी हैज बीन फाउंड डेड, एंड दैट इज द रीजन व्हाई this case has approached the court. Now custodial death is a very serious crime. Now why? Simply because the person is in the custody of police. Police is the savior of people. They cannot kill people when the person is in custody. Rule of law has to be followed. That simply means if somebody is in custody, article 22 applies. Article 22 says what? That a person needs to be taken in front of the magistrate within 24 hours, has to be given legal representation, and should be told the ground of arrest. Okay, but think about a situation, none of them is followed, or even if these things are followed and the person is in police custody and the person dies there, whose responsibility is it? It is the mandate of the state to protect people. Now it does not matter whether the person who is in custody, who has been allegedly arrested for some crime, now that is the person, or a normal other person. The state's mandate is to protect people. Now the person was not charged, or say was not given punishment by the judge or by the court. So until proven guilty, everybody is innocent. There is no meaning of any custodial death which can take place, and it should be taken very strictly, and Supreme Court has said this thing. Now in this particular case, what has happened? This person was found dead, and the police, there were several police officers who were charged with section 302 murder ki dhara, and a bail was given by Allahabad High Court to the cop. Supreme Court has set aside that bail. Okay, जब इलाहाबाद हाई कोर्ट से बेल मिल गया, so the brother of the deceased person went to the Supreme Court, और Supreme Court में जब केस को the court took the cognizance of the case, what happened? They have set aside the bail. That simply means they wanted the police officer to be in custody, because the mandate of the police officer, the duty of the police officer is not to kill people who are in custody, but to save them, to investigate them, not to kill them. That is very important, and something which has been done by the authority of the state, something like custodial death, something like death because of the torture the police inflicts upon the person on the custody. That is really very bad and sets a very wrong precedent, and that is why it can be considered as a heinous crime, not like normal crimes, and that is the reason why the bail was set aside by the Supreme Court. So let us see what is there in the slide. Supreme Court stands on the custodial death. What the Supreme Court says? It has a very strict approach towards giving bail to police officers who have been involved in custodial deaths. It emphasized greater accountability of the law enforcement. एक आदमी जब कस्टडी में होता है, so he is very vulnerable, he is not protected by anybody, and he is surrounded by police officers. Now the point is, during interrogation or investigation, If you torture the person and you kill him even by chance, I mean, that should not be permitted. Okay, there is nobody, no legal representative present there, no family member present there, nobody is present there, and not necessarily the person who is in police custody is the real accused or the real culprit. Maybe in the court it will be proved that the person was innocent. So the court has to take strict approach while dealing with the bail pleas of officer involved in custodial death. It aligns with the constitutional protection given under Article 20, 21 and 22. We are going to see what are these and other human right provisions. So apart from Article 20, 21 and 22, there are few protections, legal protections which are given against the custodial death. Indian Penal Code of 1860, punishment for murder if police leads to death, police action leads to death. Section 302 of murder is something you will be charged with if you are a police station and under your command somebody has died in police custody. Code of Criminal Procedure CRPC 1973, it mandates judicial inquiry in custodial death. Similarly, National Human Rights Commission, State Human Rights Commissions monitors and investigate cases of custodial violence. SC/ST Prevention of Atrocities Act, if such a thing happens with a person who belongs to SC and ST communities, additional protection is given, additional safeguard is given under this particular act. It becomes a very grave issue if a person from SC or ST community dies in custodial death. So additional prevention or safeguard has been given to this particular communities through the Prevention of Atrocities Act. Right to compensation, Supreme Court mandates compensation to victims' family, and United Nations Convention against atrocities, okay, against torture. India is a signatory but has not ratified it. So this is important legal safeguards which are given against the custodial deaths in India. Now, there are several cases of the Supreme Court and the cases of other courts also which are key guidelines in the area of custodial death. For example, D.K. Basu case of the West Bengal, Article 21, right to life and personal liberty, extends to victims and under trials. This is important to understand that the court has invoked Article 21 in order to tell that custodial deaths are not tolerated in this country, because Article 21 extends to convicts and under trials also. Article 21 is not only about human beings who are free, but also if a person is in detention, has been arrested because of something, Article 21 applies to all. It applies to citizens, it applies to aliens, it also applies to people who are under trial and in custody. Guidelines on arrest has been made through this particular case. The guidelines on arrest and detention, such as medical checkups and legal representation, etc. There was another case in the state of Odisha where this liability was established for custodial death, that somebody has to be liable. The responsibility has to be there on somebody, either the officer in charge of the police station or somebody who is directly responsible for custodial death, but there has to be some sort of liability on custodial deaths. We cannot tolerate these kind of deaths in our country. We are a law abiding country. The custody, the police custody is granted only for interrogation and further investigation, but not to torture the person to death. This is important to understand. It infringes several fundamental rights. We have already seen Article 20, 21 and 22. It is recognized right to compensation. We have already seen this point. So there is a difference between police custody and judicial custody. We are going to see this. So what is the purpose of police custody? To prevent further offences based on complaints or information. And here, judicial custody, detention ordered by magistrate for investigation. Sometimes the police custody is also given for investigation and interrogation. For example, a case is going on, the charge sheet is yet to be filed, and the police needs to do further interrogation or investigation on the particular topic, on the particular issue, and they can go to the court and ask for police custody of the person who has been detained in the judicial custody. So if the court permits maximum 15 days, police custody can be provided, not consistently. It can be like 2 days at one time, 5 days at another time. So police, it helps the interrogation and investigation of the police, because they can actually ask the person few questions which can help them in reaching to the truth of the case very easily, and that is the reason why police custody has been provided. But that cannot be the reason to torture a person. Now, it is in the direct control of the police. In police custody, accused is under the magistrate's custody. Now, when you say magistrate's custody, that simply means not in the court of the magistrate or not in his house. That simply means in jail, a bigger jail, such as the Hard jail. Okay, that's not a police station, that's a proper jail. Interrogation. Police can interrogate without court's approval, because court has already given the approval. See, two type of police custody can happen. If a person is arrested on a cognizable offense, the person has to be produced in front of the magistrate within 24 hours. Okay, within 24 hours. So if a person is arrested, let's say at 11 a.m. today, then the person has to be presented in front of the judicial magistrate by 11 a.m. tomorrow. Okay, within 24 hours. So for these 24 hours, the person is in police custody. Okay, of course the police can take the person on the same day into the judicial cognizance, but the point is the maximum limit of 24 hours is given. So for those 24 hours, the person is in police custody. Now, if once the person goes to to the judicial magistrate, and judicial magistrate in some or the other way sends him to jail, and then for interrogation or investigation the police needs him back in the police custody, they can request the court for police custody again, and then the person comes back to the police custody for maximum 15 days, not more than that. And those 15 days are not necessarily continuous 15 days. It can be in the chunks of 2 days or 5 days at one time and 5 days the other time, as per the need of the police for interrogation and investigation. Okay, so these are two kind of police custodies I told you. So in whichever way, if the person is in police custody, does not matter before these 24 hours or after that, after the court's permission, or even before the presentation of that person in front of the judicial magistrate. If the person dies in police custody, it is the responsibility of the investigating officer, it is the responsibility of the police in charge of the police station, the officer in charge of the police station, to look into the matter, and the liability is very much fixed and it is counted in the heinous crime. It is important for us to understand. The location is the lockup, police station lockup, and here the jail or police custody per magistrate's order. Okay, mostly it is jail. The duration is, so for example, sometimes there is no jail available in that particular district, so magistrate can ask the police to keep the person in their own custody in the lockup. Okay, now that is the prerogative of the magistrate. Somewhere the person has to be kept, and if there is no big jail or the condition is not appropriate for the person to be taken to the bigger jail, the magistrate can take the issues in their own hand and request the police to lock up the person in the police custody. That also will be considered as judicial custody, because that is coming from the permission of the judicial magistrate, and duration is maximum 24 hours before magistrate and extendable up to 15 days. We have already seen. Judicial custody is for 90 days and 60 days. In the cases of 90 days, it is for serious offences, and in the case of 60 days, it is for lesser serious offences. Then the charge sheet has to be filed in the court. Now, these three important articles are involved, and they will be very important for your upcoming prelims examination, article 20, 21 and 22. Now, many people knows about article 21, which is right to life and personal liberty. Many things are involved. This article has become mammoth. It has taken, you know, very huge twists and turns over a period of time, and so many things are included. The recently included thing was right to privacy. But this article is a very, very big and a huge and an important article. Custodial deaths, the freedom of life and personal liberty, all these things becomes the part of article 21. That simply means if a person is in custody, okay, and in some or the other way his life is threatened, he has the right to approach court under article 21. Even a person who is under detention. That is very important for us to understand. What right does a detainee have? He has this right, article 21, right to life. Nobody can take his or her life except by the procedure established by law. That simply means if the court orders, after the case is run, after the judgment comes and the judgment says that the person has to be hanged till the person dies, a death penalty is given to the person. That is the procedure established by law, and according to the procedure established by law, few things are taken up. The life of a person is taken, but not without the court's permission, not without the full case or the judgment. After the judgment these things can happen, but not before that. Before that, if something like this happens, that is simply infringing the fundamental right, article 21 of the person, right to life and personal liberty. Now, article 20 is also important because it gives protection from arbitrary or excessive punishment. Three very important things involved here: post de facto law, double jeopardy, and self-incrimination. Self-incrimination in post de facto law, everybody knows that in criminal cases the court or the punishment through court cannot be given on anything done by a person in a back date. It is always prospective. The criminal cases, the criminal charges are never retrospective. For example, an act which is punishable now and was not punishable 2 years before, and a person has done that act 2 years back, okay, the person cannot be charged today for the same act. Similarly, double jeopardy is that the same person cannot be punished for the same crime twice. If a person has been given the punishment because of one crime, that is okay, that is done. The person now needs to be set free. Similarly, self-incrimination, nobody should be made should not be asked by the police to give information about his own sort of incriminating oneself. I hope you understand the meaning of it. That the person must not be in any way, shape or form should be forced by the police to give be witness against himself. Now that is the correct statement. Nobody can be witness against himself. That is what is self-incrimination means. That is not allowed under article 20. Now article 22, protection against arbitrary arrest. This is very important. Just before a person is getting arrested, or the person who is getting arrested, the person needs to be told about the grounds on which the person is arrested. The person has to be given legal representation to defend himself, and also if there is a case of preventive detention, there also a legal representation has to be made and the ground needs to be communicated and immediately communicated to the person who has been taken into custody under preventive detention. So there are two kinds of detentions, punitive detention and preventive detention. Preventive detention is covered under Article 22 of the Constitution. Punitive detention simply means that the court has taken the cognizance and given the punishment after the trial. Okay, conviction through due process of law. Similarly, what we were discussing a few minutes back, that if a person has been given death penalty after the trial, after the due process has been followed, that is very well permissible, because punishment is the basis of the stability in the society. The punishment has to be given to person who are doing heinous crimes. Okay, they cannot be left alone, they cannot be set free. So any kind of punishment which is given, two conditions are important: trial and following of the due process. But if both of these are not done and the person dies in custody, now that is upon the state to check. Preventive detention, we have already seen, covered under Article 22. On the suspicion that the person may do something which may hurt the public order, which may be against the foreign affairs or relations of India, then the person is detained. So again, this is important for a prelims examination, that is the reason why we are reading it. Legislative powers over detention. So Parliament can legislate on preventive detention on these grounds: defense, foreign affairs and security, national security. These are covered under the union list. So preventive detention, laws can be made by Parliament and the state legislature both, but on different matters. Of course, the laws made by the Parliament are far more broader than the laws made by the state legislature. When it comes to state legislature, they can only make laws on preventive detention on the basis of security, public order and essential services, but the Parliament can make on these and defense, foreign affairs and national securities as well. So Parliament power to extend the detention. So if a person has been detained for, let's say, for 3 months, the person has to be set free. But if a committee can be made, and advisory committee is there, if they advise that the person's detention can be extended, then it is extended. Again, it is a due process of law, and all kind of law in these matters are made by the Parliament. The extension of the preventive detention, any law which has to be made, are made by the Parliament. And Parliament has also came up with a amendment, 44th Amendment Act in 1978, which has given reduced the detention by the advisory board review from 3 months to 2 months. That simply means after 3 months, a person's plea has to go to the advisory committee, and then the advisory committee decides whether the person should be kept in detention or should be set free. So 44th Amendment has reduced this 3-month period to 2-month period, but this has yet not been enforced. Okay, so that simply means that today's status is that after the 3 months of detention, the plea of the person goes to the advisory board, and it is the advisory board which decides on whether the person should be kept in detention or should be set free. So Supreme Court is very strict on this matter of custodial death. It is very strict on the matter of accountability of the police officers and the law enforcement agencies. At the same time, legal safeguard and constitutional rights are given to the people of India so that they can protect themselves against custodial torture and custodial death. So there is a need to ratify the United Nations Convention against torture. So thank you very much for joining me in this video. Simply, we have seen 2 to 3 things which are very important for our prelims examination. One thing is Article 20, 21, 22, few legal provisions, few cases which helps the people against custodial death, which in the by the Supreme Court has been declared as a heinous crime because the state is involved in killing a person in custody. Thank you very much for joining me. Next time we will come with next important topic in this current affairs series. Bye bye and Jai Hind.